Good day to you and welcome to another Paddocks Club tutorial. Today we're going to look at the issue of a recount of votes for trustees. Is this possible? What happens? And the basis of this video tutorial is a query that was asked by Stephen Barrick in the discussion forum. His story was as simple as this. A competitive election was held for trustees at the AGM. The auditor, a trusted figure, was called to count the votes per PQ. The results were announced and the chairman asked if anyone had any queries as to the auditor's conclusions. After the meeting, one of the ex-trustees asked the auditor to send him the calculations and discovered what he says are discrepancies. May well be. We have asked for a recount, says Stephen, but the new managing agent refuses, stating that the votes can only be recounted with the agreement of the new trustees. So, what is the position? Well, the answer that I gave Stephen is slightly more extensive than I gave on the discussion forum. Is the unhappy ex-trustee should have raised his or her query at the meeting immediately, when the chairperson announced the results of the auditor's calculation and before the meeting was dissolved. Here perhaps is the most important lesson in this particular tutorial. It was the chairperson's responsibility to check the results of the voting before declaring the result. From the query, it seems very much as if the chairperson abdicated that duty to the auditor and simply said, is everyone happy? Now that's not what the common law requires of a chairperson. What are the legal rules? Insofar as a recount is concerned, there's no provision in the Act or the prescribed rules for a recount of votes, a re-examination of the voting slips. And in any event, over time, who knows who's changed their minds or what evidence may change. The common law principle is that any challenge to an election result must be made immediately at the meeting. Once the meeting is closed, dissolved, and after the meeting, the elected trustees could call a special general meeting, resign and allow a re-election, and if the evidence clearly is that they were wrongly elected, I would expect them to do so. But not everybody does what one expects them to do. The unhappy owners could go to the High Court, and of course if there are unhappy owners with half the PQs at their disposal in terms of voting power, they could force the matter. But my suggestion is that the owners who are unhappy should take the evidence of the auditor's mistakes to the persons elected and ask them to arrange for a re-election in which they resign and new trustees are elected. Don't make an aggressive situation where none may exist. Some of them may genuinely have been believed that they were elected. If they refuse, then they can only be removed from office by majority vote at a special general meeting. And I have a second suggestion, which is very much self-serving. Coming soon is a book on sectional title meetings, a handbook designed specifically to answer this and many other questions. If you have any questions on this particular issue, please don't hesitate to ask them on the discussion forum.